CEU Medieval Radio, Past Perfect, the talk show about medieval and early modern culture.
Hello everyone and welcome to Past Perfect, CEU Medieval Radio program on everything medieval and early modern. I'm Roman Timoshevsky and joining us today is Jakub Razim. He's assistant professor at Palacký University in Olomouc and currently he's a research fellow at Institute of History of Academy of Sciences. Jakub, welcome.
Hello and thank you for inviting me.
Since your main research interests lay in the field of legal history and ecclesiastical history, especially in regards to Bohemian land, so maybe you could tell us more about what you are working on now.
Well, my current project involves court handbooks. These were treatises used at church courts, ecclesiastical courts in Bohemian lands. They were written in the 14th century, which was the peak of the development of the church administration in Bohemian lands. And with the help of these legal texts, I would like to reconstruct the flow of proceedings at church courts.
It's interesting that your current project deals with ecclesiastical legal history. Maybe we can start from the very beginning. So what actually was medieval law and what did it consist of?
Well, what the medieval law is, it's a tricky question. I would start with saying that scholars nowadays apply the concept of alterity. That means that they perceive the medieval law as completely different from the modern law. If I should pick a couple of features that differ or differed in the past and nowadays, it would be that the medieval law is based on customs. It is transmitted orally, and it is not always backed by an authority of a ruler, so it's not so effective as the law today. That's why also some historians or legal historians deny the very existence of medieval law, at least material medieval law. To my knowledge, nowadays, legal historians agree that there was no legal vacuum in the medieval society, but when we work with the medieval law, we need to change our thinking about what the law is.
And that's exactly what strikes me about the research of medieval law, that when we are talking about this, we are talking about the development of legal system and legal sphere in all Middle Ages, so it's 1,000 years period. So maybe you can elaborate on its development throughout Middle Ages.
Of course, there is a consensus among scholars nowadays that there was a profound change in the 11th, 12th century in the Western Europe, caused by the reappearance of digest, of the codification of Justinian, and by the revival of jurisprudence based on these ancient texts. This wave of Romanization spread across Europe, and it also reached the Bohemian lands with a delay in the 13th century. What it causes is that since that time there existed, I would say, two different legal systems of learned law and unlearned domestic law, and these two systems lived in some symbiosis. They complemented each other.
Since you mentioned before that medieval law was not so much backed by any authority, then how it was applied, in what cases?
Yeah, I would say that the problem or the question of authority needn't be connected with the modern state. There were also personalities or there were also powerful elites in the history in the past who supplemented this function of the state I mean the enforcement of the law. I tried to implement the results of legal anthropology, especially studies written by Leopold Pospíšil, who was a native from Olomouc. And he also tried to show that even in stateless societies, there can exist law. And I would argue that many of his conclusions can be applied to medieval times. So even if the enforcement of the medieval law was not so effective as it is nowadays, we can call it law.
Then the question arises, in what cases, if we can talk about it in general, it was applied in the Middle Ages, and for resolving of what problems? Is this, for example, only questions related to church, or disputes between lords and feudals, or it was also applied to resolve some daily disputes between townsmen or even peasants?
Yes. Well, we cannot speak generally about different social strata or legal circuits, because nobility had its own court, land court, then townsmen had their own court. And what is law? We can say that it is what was brought to the court and, resolved by the authority of the judge. Whether it was a town judge or land judge or ecclesiastical judge, bishop or delegated judge, it doesn't really matter. I would say that you can identify what law was by studying records of these courts. But at the same time, we have advantage with the church courts because they tend to write down the proceedings from the early phase of the existence of church judiciary. Whereas at the land court, there was also, since the 13th century, there was also a scribe, but we lack enough evidence to say more about how the dispute at the land court looked like in the High Middle Ages.
So basically, till, let's say, 13th century or maybe slightly earlier, we don't have much recordings of land courts, right?
Yeah, well, that's right. When we look back to the medieval history of Bohemian lands, we would say that the era of transition towards more elaborated Romanized law is the 13th century. Since that time, we can come across more sources, and they are more elaborated.
You already mentioned influence of Roman law, but what was the influence of church law, or as we can call it, canon law?
Well, there are some traces of canon law in the medieval history of Bohemian lands since the early times, but only since the 13th century, when the church was given immunities and emancipated itself from the rule of the magnates, there can be church procedure or Roman canonical procedure could be really applied, and the canon law could be used to resolve disputes or problems in the church society. So we can talk about the application of canon law, and extensive application of canon law since the 13th century, since the emancipation of the Bohemian church.
That's very interesting, and especially that you are taking some examples from your own geographical field of research, that is Bohemian land. But if I can turn to more narrowed focus topic within the law. So we were talking about its enforcement, its sources, but speaking about a legal system, probably a second thing which comes to my mind is that we always have kind of space for interpreting the law. And nowadays there is still space, but maybe not so much. But how it was in your period?
Well, you mean if we take the medieval law, the difference is that even if the legal custom was written down in some sort of law book, it didn't change the fact that it was oral custom or a legal custom that was binding, not the law book that contained the custom. So when we live in a society that relies on writing, we must change our approach to the medieval law, because medieval men they were analphabets mainly, and the interpretation of the written text is something else than the interpretation of a lived custom. If a medieval judge wanted to solve a dispute, then or medieval judges, because it was common that land courts decided not through the decision of one judge, but of the whole legal community that had to reach some sort of consensus. So these legal communities who played the role of a judge, they interpreted the law that was lived by people, and they tried to find analogies in legal memory. There were records of procedures that took place at the land courts, but what was more important was the opinion of the judges, and it was based on their experience and on their legal memory, on what they remembered from the past.
So generally, we can say that in the treatment of some written norms, the judge relied on his or her experience, but also on the precedents that were recorded.
Yes, of course. But if we take land court, Bohemian land court as an example, the judges may consider their past decisions as important guidelines for their decision, but they weren't bound by it, nor they were bound by Landesordnungen, or these constitutional norms, which we perceive today as constitution, but medieval judges only looked at it as some sort of aid to navigate through the law.
So it much depended on the judge, his interpretation, his experience, and just his arbitrary will.
Yeah, that's one of major differences between the land courts and the church courts, because land courts were part of the customary legal culture, and there were judges who were more acknowledged than others. There were personalities, there were rich noblemen who had a reputation, so their voice was decisive for the rest of the committee.
So there was some different scale of authority of different judges. Less experienced or less acknowledged judge could ask for the help. A more experienced one and more acknowledged one, if of course he can.
Yeah, well, yes, that's right. The authority of land court was derived from the authority of the men who were judges. This belonged to the nobility, and they learned the law from their ancestors, who also were members of the land court, and also they learned by their own experience, because they sat at the land court for a longer time, and that's how they learned the law.
Since you've raised the question of education, we can probably talk, and I'll ask you to elaborate on the legal education system in the Middle Ages. So how those court members and judges were educated, what influenced their perception of law.
Yes, the question of education of judges, the Bohemian Middle Ages, it's difficult to answer, because generally we can differentiate between land courts and church courts. We know that ecclesiastical judges were definitely, since the establishment of the Faculty of Law, since the 14th century, Faculty of Law in Prague, they studied law at the faculty in Prague. Before that time, there were also educated lawyers, but they had to travel to France or Italy. After the establishment of the Charles University, it was typical for the university in Prague that there were a narrow connection between the university and the church administration and judiciary. So teachers were at the same time judges or legal practitioners at church courts. So we have a better insight in their education. On the contrary, if we talk about the judges of the land courts, then we have to rely on allusions or scattered informations that we can find in the law books. For example, if I could mention one that is important and also attractive for modern scholars, it is a law book of Ondřej of Dubá, who was councilman of Charles IV, Emperor Charles IV, and his son Wenceslaus IV. At the same time, he was a judge of the Bohemian land court in Prague, and he wrote in two variants. He wrote a court book, and according to this court book, we can say that even if Ondřej didn't study at the University of Law in Prague, we may assume that he knew about the existence and about some basic concepts of the learned law, because there are allusions in his text that shows that he knew Roman law or church law, which was the main subject taught at the Faculty of Law in his times in the 14th century.
Now we can probably think about one more point that was always interesting thinking and reading about how the evidence was treated in the land courts or church courts and in the medieval legal system in general, because that is something which may differ from the modern law.
One point concerning the law of evidence, which is well known from the Western Europe, is that witnesses, they were treated more seriously than written evidence, charters, and so. We even know, or I even know one good example from my experience, which was a dispute over the boundaries of the property, and this case was dealt with at the land court in Olomouc or in Moravia, and there were several charters produced. It was in the 13th century. These charters were most probably forged. So at the time, the Bishop of Olomouc presided over the court, and he was suspicious about these charters. So he relied more on the witnesses that were brought to the court, which is typical for the medieval law of evidence, that voice of living was more important than the voice of the dead.
How then they knew whom they can trust as their eyewitness?
Well, if we talk about church court, then there were so-called interrogation lists. There were a couple of questions, and there were also advices to judges what they should consider when examining a witness. For example, his age, or he or she knows about the subject matter, what's the fame of or reputation of the witness, and so on. So there were questions by which a judge should determine whether a witness is or is not trustworthy.
Were there then any consequences for providing false evidence?
Well, it was common practice that the parties swore oath that they would litigate in a good faith. They won't delay. That they and their witnesses will tell the truth. So lying meant that they caused perjury or they broke this oath. So they were treated like someone who swore an oath falsely or with a bad intention.
We are already talking a lot about the practicing of law, and maybe in this direction we can also a little bit discuss its relation to the politics, which you also wrote about, especially considering the Kingdom of Bohemia. So, to what extent the lords, rulers, or some self-governing bodies as the cities, to what extent they relied on law to legitimize their decision, or even to actually decide what to do in this or that case?
Well, that's a good point. Rulers, Bohemian rulers, understood their role in the legal system, which was a role of a guarantor of the peace and justice. Good example how law was used to legitimize policy of the ruler was a case of Charles IV, who tried to promote his own land code, so-called Majestas Carolina. And in this code, you will find some provisions that change the land law in favor of the king. But what was ingenious or quite clever, that these changes were concealed as an old custom. So there was a change in a provision, and the authors of the land code added that this was held in the history as a traditional custom, which was not true, but they wanted to promote their own policy by pretending that is a part of customary law. But it didn't work, obviously, because the opponents of the King Charles, the land community, they were very well aware of the content of the land law, so they saw it through.
It's interesting that in this case we are speaking about dispute between two sides, the king and the community, and both sides are somehow familiar with the content of law. And even in case of this forging the historicity of some legal norms. What was, in this case, the position of the ruler in enforcing but also interpreting and creating law? Because we have this idea maybe from earlier period, not late Middle Ages, that the king was considered as lex animata, so the living law, and can articulate legal norms coming from his own will. How the things were going in your period, maybe with the focus on Bohemian?
There were two models of the legislation. We call them ascending or descending. Means that the ruler had the power to make law and to enforce it. But it was obviously not the case of medieval Bohemia, because as we can see, the example of the Majestas Carolina we talked about, Charles was inspired by the Roman law of the times of Justinian, who tried to highlight the idea of a ruler as a lawgiver. But this idea was in contradiction with the way how law was created, or the legal culture or legal system worked in the medieval Bohemia. So even the very idea of a ruler who gives or who creates a land code on his own was rejected by the land community because the ruler was perceived as someone who protects the law, which relied on legal customs that were defined by the legal community, the land nobility which gathered at the land court.
So it was very much matter of negotiations between different social groups, and you already mentioned ruler, nobility, but who else can kind of took part in these negotiations and law making, let's say?
Until the Hussite Revolution, this legal system was limited to the noble elites, to the ruler and the nobility. But as a result of the Hussite Revolution, a new, social power emerged, that were the towns, who also began to participate in the land diets. The land court was restricted to the nobility, but there were diets or gatherings of nobility in which townsmen began to participate and to play a role, because they become more important as military power and also as a social power. So at least at the land diets, where also legislation was passed, or new laws were negotiated and adopted. Also, the towns could or had a say to what was going on.
If to kind of sum up, we can say that with passing of time from, let's say, 13th century towards 16th century, the negotiation of law enforcement and lawmaking more and more involved different groups into it. And here I think the question of language played a great role. In what language law was produced, copied, and written in 13th century, and maybe can you compare it with earlier or later periods? So how things changed, especially towards the development of vernacular languages as Czech one.
As far as language of law is concerned, we are sure that from the very beginnings of the land courts, only language that was accepted by the land community was a Bohemian language until 17th century and the Habsburg era. But at the same time, court records were written in Latin and partly in the Old Czech. So we know about cases when someone wanted to speak at the land court German and he wasn't allowed to. So we are positive that only Czech language was allowed at the land court. At the church courts, we know about these interrogations that took place, and there were also advices to judges how to conduct interrogations in German and in Czech. So although the evidence is mainly in Latin, we know that witnesses produced their testimonies in their own native languages.
So Latin started to lose its position in the court and in the written law.
Well, it's not easy to say, because you have a language that was spoken at the court, and then you have a language of sources. We know that the land scribe, who was a part of this body of judges, he was educated in Latin and in notary arts, and he made his notes mainly in Latin, but this was not the language that was spoken at the court. So we don't have a direct evidence of how parties and witnesses reacted, or how did they promoted their claims or counterclaims at the court, because our evidence is not from the first hand, from the second hand. So we only know the records that are partly in Latin, for the most part in Latin.
As to the evidence, it's good occasion to ask you about your sources, their specificity.
Well, I focus on core books, on ecclesiastical core books, which are written in Latin, but they include allusions to languages used at the church courts. They are, very promising. This type of sources is very promising if you want to analyze the way ecclesiastical courts functioned, because at the same time these court books were part of the education at the university. They served as textbooks for students, and also they were used by legal practitioners at the church courts. They include not only the theory. Bohemian court books, they are called Ordines Judiciarii as a type of literature. They are more oriented to practitioners, so they contain less theoretical text or theoretical thoughts, and more practical advices to lawyers and to judges, and also formulas that were used at church courts. So we can, with this type of sources, we can understand how, in fact, the church courts in the pre-Hussite era, in the medieval era before the Hussite Revolution, functioned.
Very interesting and promising research sources. Maybe you can share with us some results of your research, as previous one and maybe current ones, and also how generally this study of medieval law is developed in your institution in Olomouc, but maybe in different institutions around Czech Republic and around Europe, in which you had opportunity to teach this.
If I start from the end, the research on medieval canon law in Bohemian lands was neglected for a long time, because in the communist era it didn't belong to promoted or to popular topics of the historiography. But this has changed in last decades. So I would say that there is a couple of scholars nowadays who concentrate on the medieval canon law in Bohemia. Me, myself, I work closely with two PhD students, one or two students. One is a PhD student at the Faculty of Law in Prague, and the second one studies in Olomouc, and they want to focus on system of church judiciary in the Middle Ages, and they want to, same as me, they want to understand how church courts operated. One friend of mine who also published Dominik Budský, who also published very impressive and source-oriented monography on one of the treatises. He also made this topic more popular in the community of Czech historians. He edited one of these court handbooks by Nikolaus Puchník. It is called Processus Judiciarius, and what I would like to do in collaboration with my students, or with these students I mentioned, is to maybe in the future to prepare an edition of another court book which is called Circa Processum. It is an anonymous work that was written probably in Prague at the end of the 14th century, and it is worth studying because it includes glosses and forms that were used at church courts. Which leads me to the second part of the question, what I have been studying recently. Apart from this church book or court book used by church courts, I would like to rethink the importance of another text, of another Ordo Judiciarius, which is called Parvus Ordinarius. It belongs to a popular legal literature. It was written somewhere in Paris in the first half of the 13th century. Somehow it found its way to Bohemia, where glossed version of this handbook was used by a corrector of the clergy called Pavel ze Slavíkovic. So we have a manuscript that belonged to this person who was known as a book collector, who was known as a priest, a prominent priest in the Hussite era, and who was also a church judge, a criminal judge, called corrector of the clergy. And this manuscript can be linked to this one person, has a special feature. It contains a lengthy marginal gloss. It contains notes, some allegations, some distinctions of important legal terms, but also it contains mnemonic verses. So this part or this feature of the manuscript is, in my opinion, worth studying because these mnemonic verses were considered very popular in the Middle Ages. They surely helped Pavel ze Slavíkovic, this criminal judge, to apply the canon law on cases he dealt with, because we know that he studied Faculty of Arts. He was a notary, but he wasn't a student of the Faculty of Law. So he probably needed this sort of aid to be able to fulfill his role of the ecclesiastical judge.
Maybe because we concentrated more on the research part before, we can also briefly discuss its public implication. You already mentioned why it's important to study sources of legal courts for the sake of largely neglected medieval legal studies in Bohemia and maybe also in Europe in general. But why it's important to do it with regard to the wider interest and what it can bring to us in understanding some modern phenomena, and what way do you see to popularize this knowledge?
I would say that the advantage of studying medieval legal procedure of the church courts is that it includes some ideas or some rules, for example, due process, that are considered to be pillars of the modern judicial system, continental judicial system. So, for example, if we focus on the position of the plaintiff and the defendant, on the fact that the defendant has to have an opportunity to present his story and to defend his rights, these concepts, I would say, and modern scholarships is of the same opinion, these concepts are worth studying because they are part of the modern system of the judiciary. Well, if we want to popularize this topic, or if we consider the ways how to popularize it, Actually, the one way is to hold workshops that concentrate on this topic. There was one in Brno last year that the main theme of this workshop was arbitration. Several colleagues from different countries came together, and me and them, we discussed together our experience with the way how arbitration looked like in different countries across Europe. So this, I would say traditional form of collaboration, cooperation, form of workshops, I would say it has a big advantage that you meet in person the colleagues who work with the same type of sources and who ask the same questions, only focused on their own national history. So this is one way how to popularize the topic. The other is to open courses at the university. The problem is that faculties of law nowadays in the Czech Republic, they tend to concentrate on modern history and somehow limit the amount of time spent with teaching medieval or early modern history, legal history. So in this case, the advantage of a medieval learned procedure is that it borrows ideas from the Roman law, which is considered as a sort of bridge between the ancient legal system of the Rome and the modern continental legal systems based on Roman law. So we can say that the topic of procedure can be appealing to lawyers because it can integrate the ideas, concepts, and legal institutes of Roman law.
The very last question. Is there any plans you want to share with us or any announcement you want to make?
Oh, yes, I can use this opportunity to announce that there will be a conference in Prague in January 2025. It will be held by the Historical Institute and other institutions, including Central European University. And this conference, this international conference, will focus on the law and the court, feudal court. Or maybe it's better to say feudal courts and the law. It will also include a section that will discuss the problem of the judiciary. It would be nice to attract scholars from Europe. It will be also, I think, broadcasted online, and I hope it will be an opportunity to discuss the topic of law among historians on the one side and specialists on legal history on the other side. So that's a plan for the future and how this study of medieval law can be developed.
So, Jakub, I want to thank you for this wonderful interview, and it was a pleasure to have you.
Thank you very much for having the chance to be here.